Okay, good afternoon, everyone. Good afternoon, watchers and listeners, or should I say viewers. Welcome to the fourth instalment of Clifford Gouldson's COVID-19 Accelerated Webinar program. Thank you to those who have joined us for the introductory session, where there was about 6 or 7 of us from CGLaw presenting, and also the sessions on workplace law run by Denny Clifford and commercial contracts and leasing run by Amanda Tolson and Carly Braylick. A bigger thank you to those who are joining us for the first time to listen to how rights can be enforced in the current climate from me. First of all, we're just going to do some webinar housekeeping there if you're following along with the slides. This is how you can participate by asking questions. And as they are being asked, Carolyn from our office, who's standing by controlling the slides, will shoot them through to me, and I'll try and answer them as we go. Whenever I deliver seminars, I like them to be as interactive as possible. And given this is a webinar, I acknowledge that interaction will be a little bit more difficult, but per this slide, you do have the ability to ask questions. So please don't hesitate to comment if you don't quite understand something that I've said, or ask questions along the way. Don't save them up to the end. I'll endeavour to check the questions at the end of each slide and answer them as we go. I think you'll get, well, I'm pretty sure you'll get a lot more from this session the more engaged you are. It's a human learning thing. If you're just passively sitting there and listening, you won't learn as much as if you're actually doing, and by that I mean commenting or asking questions. All right, so we'll go to the next slide. It's me there. Lawyers love a disclaimer, so please read that, of course, very carefully. Okay, look, before I delve into the nitty-gritty legal aspects of what's changed with the law as a result of COVID-19, I wanted just to give a bit of background. It always helps to have some context in which I'm giving this presentation today. I attended a webinar yesterday during which a senior economist from the Commonwealth Bank relayed some interesting information about the current economic environment. One of the things he said, which is, and look, some of this is not going to be too surprising, but it was interesting to have it confirmed. The International Monetary Fund has described the current economic climate as the greatest recession since the Great Depression back in the 30s, the 20s and the 30s. So that's a little bit depressing, excuse the pun. The unemployment rate looking like is about 10% at the moment, which is obviously very high, but analysts are saying it could have been around 15% without the various government stimulus packages that have been released. Business confidence, trading and profits, unsurprisingly, are at record lows, whereas unemployment, though, is at an 11-year low. And of course, whilst that's a large unemployment rate, it could have been worse, as I said before. The $130 billion government stimulus package seems to have stemmed the flow a little bit, or should stem the flow even further around business confidence, trading, profits and unemployment. But the expectation is that there'll be further decline with all 4 of those factors. In a bit of good news, the decline in international oil prices, as I'm sure all of you have seen, has resulted in reduced fuel prices, which could assist business operating costs. Couple of industries they touched on in this webinar yesterday were construction and the not-for-profit industry. With construction, there's a likely labour shortage. There's likely to be a labour shortage next year when government infrastructure spending likely increases to try and stimulate the economy even further. Not-for-profits donations are down, unsurprisingly, but demand for their services is up. So it's a bit of a double whammy for them, unfortunately. There was a recent change to the Job Seeker program whereby all charities are now eligible for the Job Seeker assistance if their revenue is down by 15%. So that makes it a bit more easy to access for that industry. One thing that Amanda and Carly may have touched on Tuesday is rent relief as opposed to rent deferral. As I understand it, if a commercial tenant's turnover is down by 30%, then the rent relief or the rent reduction is 15%, and the other 15% is deferred. In other words, there's a discount on rent by 30% of the normal rent, and rent relief is that you'll never have to pay 15% of that 30%, but the other 15% is deferred for 6 months, and then after that 6 months you can pay off that 15% over 12 months. This is, I guess, relevant to enforcement of rights by landlords. As I understand it, they must enter into mediation with their tenants if the tenant is behind on rent and they can't kick them out. What's being referred to as the ATO cash flash, as I understand it, this reduces tax debt but is not in the form of actual cash injection into businesses. So but that may well free up cash that would have otherwise gone to the ATO. State government-based relief, there's payroll tax relief in certain circumstances. And one thing I heard yesterday was that there are business grants available in certain circumstances for certain professional advice. So that's, again, a bit of welcome news. Loan repayments in many cases from financial institutions are being deferred, but interest continues to accrue on the outstanding balance of the loan, or in some cases, some lenders are capitalising that interest. So I guess my point behind relaying all of that is it's important that some businesses will later need to deal with any liabilities that they have deferred, or in some cases, if their creditors are chasing them now and they have too many debts that they can't pay as and when they fall due, even taking advantage of all of the assistance that's out there, then there are insolvency measures that can be used to save a company or a business and not put it into liquidation, for example. Voluntary administration and entering into a deed of company arrangement is one example of where early intervention and use of one of those measures can be the best way to just pull through this difficult period over the next sort of 6 months or so. The forecast that the analyst gave yesterday was that there will be a spike of insolvencies or liquidations, unsurprisingly, March, April, and on the way down in May. There'll be a temporary back to usual number of insolvencies and liquidations in June and July. The crisis, as we know COVID to be, is tipped to end at the end of or in August approximately. But then they are forecasting another spike in insolvencies and liquidations in September and October because of all of the payments or liabilities that may well be deferred in the next month or two. So I think there's some, and it all depends on how big that spike is or how small it is on decision making by business owners now. In a somewhat silver lining, the forecast was that it should be back to usual business conditions, as usual as they can be anyway, given what we're all likely to experience in the next 6 months, by the end of the year, by November or December, in terms of numbers of insolvencies or liquidations. So that, again, the point of this is there may well be for both people owed money and people who owe the money, accrued liabilities are still going to have to be dealt with at some time or another. Now, it might be the best thing for a business to defer those payments to later in the year, but still going to pay one day, and it's not really the too distant future. In other words, it may assist cash flow now, but it's still a debt on the balance sheet. And as I'll go into later on, short-term loans or debt finance options, in addition to legislative or contractual deferrals, may well be the way to be to get those debts paid now and be able to pay them off at a more comfortable rate. So if we move to the next slide. So these are the black letter changes to the law as a result of COVID that I'll cover today. As a result of all of that challenge that businesses are going through and individuals as a result of the coronavirus, the government's made some changes to the Corporations Act and the Bankruptcy Act to encourage businesses and individuals to keep trading to cushion that impact. First of those I'll cover changes to the Bankruptcy Act. Now, bankruptcy notices are a tool available to someone who's owed money by an individual. They are a form that you file with the Insolvency and Trustee Service of Australia. You pay a fee, the form's issued, and you can then serve it on the individual who owes you money. And the point of doing that is you can't then go on to enforce or force the debtor into bankruptcy unless they first committed an act of bankruptcy. And an act of bankruptcy is the failure to pay the amount set out in a bankruptcy notice within 21 days of being served with a bankruptcy notice. That's the usual state of play. Now, as from towards the end of March this year, debtors have, or recipients of a bankruptcy notice now have 6 months from the date that they receive a bankruptcy notice to either pay the amount in the notice or apply to the court to set it aside or for more time to pay. And that's been increased from 21 days, so a significant increase in the amount of time they've got to do something about it. And the minimum debt that can substantiate a bankruptcy notice has been increased from $5,000 to $20,000. And these changes, this extra time, and more importantly, are in place for 6 months, so until the mid to late September this year. Any questions, Carolyn, that have come through as a result of what I've said so far? Okay, none yet, that's fine. We'll move on to the next slide. So there's also been some changes made to the Corporations Act, and they relate around creditor statutory demands and insolvent trading. In relation to statutory demands, they are a similar tool available to someone owed money to a bankruptcy notice, except creditors' statutory demands can only be served on companies rather than individuals. And again, they act in much the same way that a person owed money can't apply to the court to wind up the company that owes them money, i.e. force them into liquidation, unless the company is insolvent or at least deemed to be insolvent under the Corporations Act. And one of the ways in which you render a company insolvent is serve a creditor statutory demand on them and then wait 21 days. And if they don't pay the debt within that time, well, then there's a presumption that the company is insolvent. But that, again, similarly to bankruptcy notices, the period of 21 days to either pay the amount in a creditor statutory demand or apply to the court to set it aside or for more time to pay has been increased to 6 months from 21 days. And the debt, minimum debt to found a creditor statutory demand is up from $2,000 to $20,000. So again, the time frame, the amount of the debt is probably not as big a change as the time to pay or or to deal with the creditor statutory demand. Both bankruptcy notices and creditor statutory demands were attractive to people owed money because they resulted in much quicker action, or they required much quicker action on behalf of the debtor than if you simply went to court and sued the debtor for the amount. You get a result reasonably, or usually much quicker than if you went to court, and particularly if the debtor contested the court action. Now, 6 months to get over the initial step in either a creditor statutory demand or bankruptcy process is relatively a long time in a debt collection process. And we'll come to what you might be able to do instead of those two options a bit later on in the presentation. Insolvent trading. Now, for those who don't know what that means, basically, usually when a company incurs a debt, the company being a separate legal entity is the entity liable to pay the debt, and the directors, being separate legal entities from the company, are not personally liable to pay the debt of the company. That situation is reversed if the company incurs the debt whilst it was insolvent. In those cases, its directors become personally liable for the debt as well as the company. But there's a moratorium or a freeze on that personal liability of directors for 6 months. So again, if a company incurs a debt whilst it's insolvent, technically insolvent, and the simple test of insolvency is when a company can't pay its debts as and when they fall due for payment out of its own money. So directors now can effectively, or companies can effectively trade insolvent and incur debts while they're insolvent, and the directors are not personally liable for any of those debts incurred between now and mid to late September this year. A bit of a shame for creditors, but I guess it does stimulate the economy in theory. Any questions on that slide, Carol? None so far, which is fine. Okay, so I just wanted to touch on some existing law which impacts on enforceability of rights. There are various types of relief or protections to debtors or people on the receiving end, I guess, of action or disputes to enforce contracts. And I'll just run through these briefly. So the insolvent trading aspect or protection I just talked about is sometimes been referred to as a safe harbour for directors from an insolvent trading claim. There's already a safe harbour for directors from insolvent trading claims. And to be eligible, the company or the director's company must have satisfied all the statutory requirements, like, for example, paying its tax, paying its employees, super, and all that sort of stuff. But if you're a well-behaved company, then and the directors develop one or more courses of action that are reasonably likely to lead to a better outcome for the company than appointing an insolvency accountant to wind up or liquidate the company. And you get that, you develop one of those courses of action with the assistance of a qualified advisor. Now that can be a lawyer, that can be an accountant, it can be an insolvency accountant, or there are others out there who term themselves as restructuring or turnaround advisors. If a director does that, then even though the company may have traded and incurred debts whilst insolvent, the director is protected from an insolvent trading claim against him or her personally. So that was there already before COVID. Similarly, ipso facto clauses. So they are clauses in a contract that give one party the right to immediately terminate the contract upon the occurrence of usually an insolvency event by the other party to the contract. So, for example, if one party went into liquidation or administration or receivership, then the other party, if there was an ipso facto clause in the contract, then that party could terminate it. But for contracts entered into after 1 July 2018, the operation of those clauses, those ipso facto clauses, is stayed if there's a termination, or the right to terminate is stayed by reason of only one party's financial condition. Unfair contracts under the Australian Consumer Law. Now, this protection is only available in certain circumstances, so it only applies to certain contracts between certain parties. But if all of the prerequisites are met, then a court can deem a contract to be unfair and therefore unenforceable if it's a standard terms or a take it or leave it contract that give all of the powers in the contract to only one of the parties. So it's an attempt to try and remedy any power or bargaining imbalances between the two parties by powers to one party. An example would be the power to just vary the contract unilaterally, like without agreement of the other party, or just to terminate it at will on no notice. They're the sorts of things that a court would be looking to deem invalid if a contract existed, and again, the requirements are met before you can access that protection. And the last existing protection is a variety of contractual types of contractual clauses or mechanisms that, particularly if you're again on the receiving end of an action or a dispute of someone trying to enforce a contract at the moment and you're just not in the position to perform it, or you need more time to perform it, then a force majeure clause may well apply. I know that Amanda and Carly covered force majeure on Tuesday in their presentation, but basically it's a common clause where there is an act or an event that happens outside both of the parties' control, like an act of war, an act of terrorism, and possibly even a pandemic. And depending on the wording of the particular contract, it may entitle either party to either more time to form an obligation, the obligation to be waived, or the contract to come to an end. Frustration is similar in the sense that if the subject matter of the contract doesn't exist or can't exist or can't be brought into existence because, for example, of a pandemic, then the contract may be frustrated and therefore come to an end, and neither party has rights against the other. Termination is pretty self-explanatory, and variation is basically changing or amending the contract. For example, if you need more time again to perform an obligation like to pay, then there might be rights in your contract to vary it, so you've got more time to pay. Any questions there, Caroline? Okay, so there's been a question that's up on the screen there, so everyone should be able to see that one. Anything that's announced lately with sole party commencing proceedings rather than issuing a statutory demand? No, is the short answer. You are still able to sue. There's been nothing announced that I'm aware of that stops anybody who has a cause of action against another party from suing them. For example, for a monies owed claim. And in fact, that's where I was about to get to on the next slide, so that's great timing. So other enforcement, other than a statutory demand or a bankruptcy notice, you've got an action in one of the courts, depending on how large your claim is, up to 150,000 magistrates court, 150 to 750,000 district court, and above 750,000 Supreme Court. and Queensland Civil Administrative Tribunal claims up to $25,000, unless it's a building dispute, and then it's unlimited amount. Look, there's been practice directions issued by the courts and other measures taken about how matters are to be heard. They all boil down to this, as we've seen it so far. Effectively, unless you seek and receive the court's permission to have an in-person, what we call oral hearing, all hearings of applications, and even will be on the papers, or in other words, without an oral in-person hearing in court. So you would file what are called submissions. They're your written arguments. Both parties do that, and then the judge or the magistrate or the tribunal member makes a decision based on that written material only, and there's no verbal submissions in court. What we have seen though in practice, at least with the Ipswich Magistrates Court, as an example, are not hearing anything unless it's urgent. So not even dealing with matters on the papers. They're just pushing back hearings, and they'll be dealt with as normal, i.e. in court in person, but not for 3 months. So anything that's been set down at the moment is being adjourned for 3 months, or any new matters are not being listed until July. So arguably, debtors have got 6 months to pay if they get a bankruptcy notice or a creditor statutory demand. Sorry, that's not arguably, that is the case. And then arguably, it may not be so much quicker in the courts, it's seeming. But I still think the option is there to sue, and in the Queensland courts and in QCAT, the debtor has 28 days to put in a defence, and if they don't, you can get default judgment, and you can enforce that judgment if any of the enforcement options are available. So it may well be faster now to go through the courts, as long as you don't need a hearing, which you don't for default judgment and enforcement, unless you do an enforcement hearing. But by and large, you don't need a hearing in civil matters anyway. So it may well be faster just to go through the courts and just do it all on documents. That would be my advice at the moment if you're looking to take formal steps. So I hope that answers that question. The reason I use that word formal steps was deliberate, because I've got over the next couple of slides some informal or practical steps that I think in the current environment are worth considering. So these are for creditors, so if you're owed money and you need to recover money that's owed to you sooner than September because that's hurting your cash flow, what do you do? Well, strange times call for unusual measures, so I think it's time to think a bit outside the box. So again, for people owed money, look carefully at your current insurance regime, and this will be more for businesses. Some businesses I know have debtor insurance or business interruption insurance, and that might be of assistance. So talk to your broker, scour your policies. There are some businesses out there that are doing better because of COVID in some industries, and I think with increased demand, there may be the temptation to increase pricing. Need to be careful of that because the ACCC, the Australian Competition and Consumer Commission, may perceive that to be price gouging under the Competition Consumer Act, so just be careful of that. Work with your debtor. Now, this, I guess, has some practical restraints if the debtor doesn't want to work with you, but make sure they're aware of all the government support packages, particularly if they're a business. Encourage them to access as many as possible, because if they're doing a bit better, then they're more likely to be in a position to pay you. And look, something is better than nothing. And so entering into a payment plan or perhaps accepting a reduced lump sum may well be better than getting nothing if the debtor, particularly if the debtor becomes insolvent. So I'd encourage to consider that. Try to get some security in place now. And what I mean by that is with existing customers, you might want to vary or amend your contract to say, okay, well, can you give us the right to caveat any real property you own if you don't pay? Can you give us a security interest over any personal property or a mortgage over any real property? Can you pay up front if it's a new contract? Review your credit terms for future dealings that might shorten payment terms to cash on delivery, for example. Prevention is better than the cure, so try and avoid debt where you can, or avoid people not paying you where you can as best you can. And if you are going to delay taking action against a debtor because you're going to enter into a payment plan, or you're agreed to defer payment for a while, and you're not going to sue them, or you're not going to defer, but you're just not going to sue them, put a time limit on it and reserve your rights under the contract to take action later on, if and when you desire. And try and get something in return. I mean, if you're going to allow a debtor to pay the debt off or not start paying it for longer than your usual payment terms, where you're agreeing, okay, look, I'm not going to sue you, but you still got to pay the debt, try and get something in return. I'm not sure, perhaps a higher price when they do start to pay it off, or interest, or covering any costs you've incurred because of the delay. And finally, finance. Now, this is probably a last resort, but debtor finance is something that is out there. And how it works, as I understand it, is the debtor, the creditor is paid by the debtor finance company in full, and the debtor pays off the finance company with interest over, say, 6 to 12 months. But if the debtor misses 2 payments in a row, then the creditor has to pay the finance company back whatever the balance of the debt is at that time. Alternatively, there's factoring, which is where you can sell a debt to a factoring company. If you're owed a debt, you don't want to chase it, you don't want to spend any money chasing it. You sell it to the finance company for less than the amount owed, and they recover the whole thing, and that's how they make their money. Right, just quickly, the last slide. I know we're just going a little bit over time. Now, these are some practical tips for people who owe money. Again, insurance review to see whether you've got any insurance that might cover some costs or losses you've suffered as a result of COVID, but ensure to check the terms of the policy that pandemics or similar are not excluded. Goes without saying, access as much government assistance for which you are eligible. No need to do it any tougher than you have to. Take advantage of all of the law changes, like we've been discussing today. Make sure you insist on the 6 months to pay if you get a SAP demand or a bankruptcy notice, or you can't be evicted for non-payment of rent if you're a tenant. Take advantage of any favourable clauses in your contract, or if you're about to enter into a new contract, ensure that they're included, like we're talking about before, force majeure, termination and variation. And then I would have thought in the current environment that the people who you owe money to are likely to be more open to negotiation, whether it be deferral, so pushing the debt down some months away if you can, or at least enter into a payment plan to start paying it off that's in manageable chunks, or again, say, look, get an agreement in writing from the person you owe money to. I won't sue you, but in return, I'll pay you some interest or a higher price for the goods or the services, an uplift, or I'll pay any costs you've incurred as a result of the delay in payment. It may well be cheaper than taking out a loan to pay the debt. But again, that's the last option. Short-term loan interest rates are usually pretty high, so better to seek to negotiate with your creditor without reverting to a lender if you can. But if that's not available, then again, debtor finance applies equally to if you owe money. Talk to your creditor about that and say, look, can we debtor finance this? Can I pay it off? And you get paid up front or the amount now. Any questions before we finish off, Carolyn? I think we've just got a few final slides to go. No further questions. Okay, no trouble. Well, I think the next couple of slides are just a reminder of our upcoming webinars. We've got 3 to go in our series. They're on the screen there. Be sure to tune in if any of those topics interest you. There was an introduction to those in the first seminar, and those that are available. Those that are available on YouTube, they're on the screen as well. Those are the 2 that have been that I referred to earlier. Look, to finish off, stay in touch with people, remain socially connected, especially with family and friends, and support local business where possible. That will help get us all through. And if you want to speak further about anything that I've covered today, please don't hesitate to contact me. My details are on our website. So thanks again for tuning in.